Democracy in action.
Our businesses died sudden deaths. Prostitution and robbery became the only gainful employment for graduates.
They'll draw their constitution to protect themselves.
The fallouts.
When I see Abuja, I sit back and I say, wow. You turn off this road, you go here. Why don't we have
It's not getting any better because of what we're doing to ourselves here. People are just leaving the town in droves. I'm going to Abuja.
Catch Kingsley One every Saturday on this frequency, 11 a.m. to 12 noon.
My name is Kingsley One Wali.
Democracy in action. Only on Today 95.1 FM, Port Harcourt.
If I ever get the opportunity to talk to him, I'll be, sir, whatever you do, build commerce again.
We have been on the journey of democracy since the year 1999, effectively 1998. That was when they conducted the first democratic elections into the local government cadre of government. And since then, we've had all kinds of issues, ranging from the good to the bad, positive to the negative. And there have been cases that one would say, okay, I think we're making progress. It's all part of development. All kinds of things are thrown up, and then what matters is how these issues are resolved. In fact, it's got into the state that sometimes people want to say, is this democracy even worth it? But I guess democracy remains the best form of government. In the last couple of weeks or days, we've had issues over some aspects of democracy that make us sometimes, some people want to say, there we go again. Are we sure we are prepared and we're ready for this democracy? Especially within the PDP, we've had issues that border on both internal democracy and good governance, especially within the context of the struggles that come, and we ask why are we going through all of this? If it's all about serving the people, why this do or die politics? It was climaxed with the judgment by the Honorable Justice Okona Bank of the Federal High Court in Abuja, who delivered what you call a knockout blow or punch to His Excellency the Governor of Abia State. Pardon me if some people living now refer to him as the ex-governor, but it's not my bit. Some have said that in the face of the law, he's no longer governor. This morning, we'll try and see what the law says. As much as possible, we appreciate the fact that we all have our personal views about what is happening in Abia State and possibly a bit of what's happening in Edo State. Within the context of the judgments have been given by judges. I remember this morning I said to somebody and I asked him if what we are going through now is democracy in action or demonstration of grace or crazy demonstration, as fella said. This morning with me on Democracy in Action in the studio is a friend of the house, a legal practitioner and a civil rights activist, Charles Aholu. Charles, you're welcome to Democracy in Action.
Good morning, Mr. Kingsley, and good morning, Rivers people.
I'm sure you've been around. You didn't travel out of the country. Even if you did, you still have access to news. What, first and foremost, do you think is playing out with regards to Abia State? What is the problem there? Is it a political issue or a legal issue?
Thank you, Mr. Kingsley Wali, for that question. I think what is playing out in Abia State is both political and legal. But I think the law regulates politics. I'm one person that believes that the law regulates politics and not the other way around. First, we must be able to gauge the judgments coming from the High Court, and to gauge the judgment and see what it actually, the contents of that judgment, before we can actually determine whether what is playing out is legal or political. And I think the Federal High Court made a declaratory order saying that the governor of Abia State, or as some people would like to refer to him now, the ex-governor of Abia State, falsified some tax documents, and on the basis of that, the court held that he was not declared, that he was not duly sponsored by his political party in accordance with Section 177 of the Constitution and Section 31 of the Electoral Act.
What do these sections actually speculate?
For the purpose of clarity and for the benefit of our readers, our listeners, I would like to read what Section 177 provides. Section 177 provides that a person shall be qualified for election to the office of governor of a state if A, he is a citizen of Nigeria by birth, B, he has attained the age of 35 years, C, he is a member of a political party and is sponsored by that political party.
So within context, this section you're dealing
Yes.
with has to do with the fact that the party has to sponsor him.
Yes.
Okay.
So during the primaries, Mr. Oga, who came second in the PDP primaries in Abia, felt that certain depositions, you understand, exhibited by Dr.
Well, can we just say certain documents provided?
Okay.
When you say depositions,
Sorry, we are lawyers, and
they might get a little bit.
Sometimes we live under the impression that we're permanently in a courtroom. So there certain information which were published were false. And I think it will be for the benefit of our listeners. Let me read out Section 31 of the Electoral Act. It says that every political party shall not later than 60 days before the date appointed for a general election under the provisions of this act submit to the commission in the prescribed forms the list of the candidates the party proposes to sponsor at the election. Subsection 2. The list or information submitted by each candidate shall be accompanied by an affidavit sworn by the candidate at the High Court of a state, indicating that he has fulfilled all the constitutional requirements for election into the office.
Okay.
That is including due sponsorship.
Okay.
3. The commission shall, within 7 days of the receipt of the personal particulars of the candidate, publish same in the constituency where the candidate intends to contest the election. 4. A person may apply to the commission for a copy of the nomination form, affidavit, and any other document submitted by a candidate at an election, and the commission shall, upon payment of the prescribed fees, issue such person with a certified true copy of the documents within 14 days.
Okay.
Yeah. Then 5, a person who has reasonable grounds to believe that any information, this is the basis of the action. A person who has reasonable ground to believe that any information given by a candidate in the affidavit or any document submitted by the candidate is false may file a suit at the High Court of a state or Federal High Court against such person, seeking a declaration that the information contained in the affidavit is false. If the court, subsection 6, if the court determines that any of the information contained in the affidavit or any document submitted by that candidate is false, the court shall issue an order disqualifying the candidate from contesting the election. That is the primary election.
Okay.
You understand? A candidate for an election shall, at the time of submitting the prescribed form, furnish the commission with an identifiable address in the state where he intends to contest the election, at which address all documents and court processes from either the commission or any other person shall be served on him. If you go down the whole hog, in subsection 8, even a political party who sponsors a party. In fact, this offense here is strict. If you sponsor a party who have provided false information, you can be convicted as a political party, and upon payment of fine, and upon conviction, you can be levied a fine of 500,000.
Okay.
You understand? That is the provisions of the law.
No, see, my problem here is the nitty-gritty of the reason why the Federal High Court disqualified Honorable or His Excellency Igbazo. It's what I would rather that we don't, because since we can only be speculating on that. For example, he claims that he was a staff of Imo State government for a period preceding his both the primaries and the election. So he can be accused of, there won't be any need for him to produce a forged document. And if there was any error on the face of the document provided by the Board of Internal Revenue, that it wasn't his problem. So that's his own argument. So since we cannot really begin to deal with that, I would rather that we restricted ourselves to the process after the judgment, that is the bone of contention. For example, the court said he's been disqualified, that he wasn't qualified to run for the governorship, and said that his certificate of return should be retrieved and a fresh certificate of return given to Uchechukwu Oga,
Samson
Oga, the person who came second. And that was the decision that INEC took, and that is what everybody is all about now. Why would INEC do that when, now let's just say this is what the argument is. It's not what I'm saying, that the judgment was given that the man reserves the right to appeal, which he had followed. He appealed. And some are saying that because he has just appealed, INEC should have taken an action. And of course, the law says that notice of appeal is not, cannot act as a stay. But they're saying that beyond that, we filed an application for stay, and INEC was informed. Now, what do you think transpired?
Well, just like you rightly pointed out, the mere filing of a notice of appeal does not operate as a stay of the judgment of the lower court. I think the only thing that can operate as a stay is the stay itself, if the application for stay is actually granted. But then in law there's what we call the doctrine of lis pendis.
Okay.
You understand? And that doctrine provides that once a subject matter is the subject of a legal process which have been served on the parties
involved
in that matter, that no other person, none of those parties is free to take any action with respect to that matter. So you see, the law is not a brooding omnipresence in the sky. It is the prophecies of what the court will do in fact, and each peculiar circumstance had to be taken into cognizance. So the question is whether those processes have been served on INEC or on INEC and OGA. So I believe personally, from a legal perspective, I think if those processes have been filed on them, it was wrong for INEC to issue a new certificate.
Is it that it was morally wrong or it was legally wrong?
It was legally wrong. If they have been filed on INEC, but I said we don't have that information. We don't know if they have been served. They ought to have been served on all the parties.
If it's been served on INEC,
not
yes. Served on.
And then the question is whether by the nature of the service that was served on INEC, whether that service on INEC was valid. You understand? Because sometimes you can serve a process at a place ordinarily which you are not supposed to, and that in itself is not valid service.
Okay. You
understand? So these are legal issues. And then from the perspective of INEC, one will not blame INEC. If you look at the content of the declaratory judgment, that judgment provides that a new certificate of return should immediately, emphasis on the word immediately, be issued on Samson Uchechukwu Oga. So INEC wouldn't have. I don't think INEC went to traverse any law. You understand, or the order of the court to immediately issue, because the word immediately, as defined in Webster Dictionary, means without delay. Without delay.
But is there any legal authority or process which requires that before a judgment either way is implemented, some time frame is given?
Some time frame, just like I explained. I said,
because immediate might be vague. Some might say immediate means 1 week. Some might say immediate. But is there any part of the law that says once there's a judgment, parties are supposed to wait for like 1 day, 2 days, 3 days, 1 week, or no day, or no week?
I think we should get this thing straight. In the construction of statutes, a court is bound to give words as they appear in statutes their ordinary natural grammatical meaning, except where the ordinary natural grammatical meaning can lead to absurdity.
Okay.
You understand? So the word immediately means without delay. So INEC, I believe, on the strength of even the declaratory judgment and the consequential orders made pursuant to that declaratory judgment, INEC was right to have issued a certificate of return to Uchechukwu. That is provided they were not served with the
as at the point
of issuance. Yes. Provided they were not served with the application for stay of execution and the notice of appeal.
Now, what if the certificate of return was dated, like, I think that judgment was 27th?
Yeah.
It was dated 27th of June, and then the notice was served by 29th, and INEC issued the certificate on the 30th. What does that imply? Because it was written 27th or 28th, which was within the period when they've not been served. I don't know if I'm making some sense here.
Please, can you come back? I need to get it.
The certificate of return is dated 27th.
Yeah.
INEC is served 29th.
Okay.
INEC issues certificate 30th.
Okay.
What date will be operative here?
I think the date on the face of the document, the date that it was issued, is the operative date. I think that date will be the operative date.
Let me say, here you have the position of the law is that when a stay of execution and a notice of appeal has been filed, it is incumbent on all parties to stay action to avoid a situation where one's interest will be rendered nugatory. Augustine Alege, National President, Nigeria Bar Association.
That is it.
A notice of appeal is clearly not a stay, and INEC has broken no law in issuing certificate of return to OGA. But they should have relied on the prudential principle by cautioning themselves, given the fact that they have received a notice of appeal, which in itself does not constitute a stay of execution of the order of the court. However, INEC has not broken no law by issuing certificate of return to OGA. Olisa Bakoba, SAN, yes. Former NBA president. Federal High Court ordered that Uche Oga be issued with certificate of return and should be sworn in as governor of Abia State. INEC complied with the order. The order ex parte issued by a judge in Abia State High Court is illegal and contemptuous. The Abia State High Court cannot sit on appeal over the order of the Federal High Court, as it is a court of concurrent jurisdiction. Femi Falana, SAN, life president of West African Bar Association, WABA. Now, looking at all of this, you have the former president of the bar, you have the current president of the bar, and you have the president of West African Bar Association, and they are all singing different tunes.
You see, that is the beauty of the law.
I find it extremely difficult to reconcile, especially the statement of Olisa Bakoba and Austin Alege on this issue. Please help us reconcile.
Well, I will only give my personal opinion.
Now, what signal does that give to the common man walking the street?
Well, it gives them the signal that one, that the judiciary is not forging a common cause. You understand, and that impression that impression is a non-legalistic impression insofar as I'm concerned.
Okay.
Lawyers have their opinions, and that is why we are divided on certain issues. So that those are their opinions, and I want to say with the greatest respect to even the
Don't you
populace.
think that the president of a Nigerian bar station should be circumspect when it comes to making a statement at this point in a situation that it is worthy? Because a lot of people are going to say the NBA president said this. Like it or not, the truth of the matter is that our society is largely illiterate and ignorant, and they hold on to certain statements by a certain category of people. So I will expect, not just, yes, everybody's entitled to their opinion. What I'm saying here is that shouldn't the lawyers, the judges, consider the consequences of what they say before saying them?
Well, I believe that...
Let me just say something. Somebody said, we now live in a nation where doctors destroy health. Lawyers destroy justice. Universities destroy knowledge. The press destroys information. Religion destroys morals, and the bank destroys the economy. It's instructive. Is it not easy for somebody to say the Nigerian lawyers are destroying the legal system?
They are destroying
The justice system.
Well, I think that is a fallacy of hasty generalization. Yes, some lawyers are destroying the justice system. Some lawyers, but you cannot generalize to say lawyers. If you say lawyers, you include everybody in that category.
Yeah, because if you take a case of this Abia State issue now, every lawyer knows that the Federal High Court and the High Court anywhere are courts of coordinate jurisdiction. And somebody goes, files a paper at the court of the High Court of a state, and expecting that should serve as appeal. Is it not worrisome?
It is very worrisome. But just like I said these are their personal opinion. I think the box will stop at the table of the court. It is the court that will take the final decision, and then it is the court decisions that we are going to obey on this matter, not whatever the president.
Are you not worried about the fact that there's a possibility of people reacting, spontaneous reaction to some of these things, and likely to cause the breach of the peace?
There is a natural. There is a crisis aspect to this whole imbroglio, which I believe should be managed by the security authorities. Opinions like this can sway people to action.
Precisely.
We understand, and we believe that if you find yourself at that top level, the top level position like that,
I equally had the federal commissioner, the INEC federal commissioner
Yes.
for the Southeast.
Yes.
He was speaking like an APC member. I'm worried about the fact that somebody holding that kind of position used the word that, in fact, the judgment that the court gave was wonderful. He used that word wonderful. That definitely shows that you're partisan.
Yes, I agree with you. If you'll find, you see, the INEC is referred to as Independent National Electoral Commission.
Yes.
But then the question that we should ask is whether they are really independent in substance.
Even if you're not independent in substance, are you supposed to make such profound statements?
So when you find yourself as a national commissioner of INEC or a commissioner of INEC in charge of the Southeast, you shouldn't want to be making those type of statements that will give you away as a highly biased official of the electoral umpire.
I think I want us to look at the comment by Ozabakoba, SAN, former president of General Bar Station.
Yeah.
When he said that yes, INEC was probably not wrong in their decision to issue the certificate.
Yes.
Now, shouldn't INEC have shown some measure of caution, exercise some caution, rather than, if you like, the hasty?
No, I don't agree with you. I said everything will be contextualized. The question is whether the notice filed by, whether INEC had no knowledge of, one, the notice of appeal that have been filed in court, and with the motion for stay of execution. I said I think it will be contingent upon that knowledge. If they have knowledge of the stay, the application for stay, and the notice of appeal, INEC will be very wrong to have issued that certificate of return to organ under the doctrine of lis pendis.
Okay.
That is the position of the law, and it's very clear. So everything should be placed in context.
I watched
Everything should be placed in context.
I watched the Attorney General of Abia State yesterday, and he was actually showing a document to show that INEC was aware of the application for a stay.
You see, there is something we must understand. A notice may or may not be valid.
Yeah, what makes the notice invalid?
Now, what makes it invalid is one: if it is served on an official and on an official who is not
authorized
to receive that application.
Now, can you just tell our listeners? Can you just tell our listeners what is the ideal process? Because I know that sometimes you want to serve somebody or serve a party in a street, and what do? They avoid service. You need to go back to court to get an order for substitute service.
Yes.
Now, in the circumstance of INEC, who is the proper person?
The secretary of the commission.
So if the order is not served to the secretary,
yes,
couldn't that order be received by the secretary, on behalf of the secretary rather, by any of his staff, like his PA, assistant, and all of that? Anybody in the office of secretary of
serve it on the secretariat. In this case, it was served on the legal department. So, and the legal department is not authorized to receive such
notices.
Yes, such notices. It ought to be served on the secretariat.
You have proof of the fact that it was served on the legal department?
Yes, of course. We heard it yesterday. Even the Attorney General of Abia State said that it was received by one Ibrahim from the legal department of INEC, of the National INEC.
Without boxing you here, probably didn't prepare. I don't know if you can help. Is there something to back up your comment here that it was served on the wrong person? Like what's on the legal department? Because you would expect that a process that has to do with a matter in court, and the legal department might be in a position to receive it on behalf of the commission.
I agree with you 100%. I agree with you 100%. But then you have to look at.
I'm just worried here that it smells like, to me, like some hanky-panky is at play here. Let's not forget that such fundamentals must be addressed in the way they should be, honestly, and not allow it to be a precedent. Because my people say that once you allow bad conduct to continue, it becomes some kind of
you see, as much as possible, we'll try not to be biased here.
Yeah.
You understand? That was why I said from the very beginning, if INEC received notice of the application for stay of execution and the application for notice of appeal, that there is no way they can issue that certificate to Oga. There is no way the issuance of that certificate would have been valid under the doctrine of lis pendis. You understand? So that is the position.
Technically,
INEC
was right.
Yes.
If it was served on the legal department, not the secretary.
Yes.
Doesn't the argument of Olitabakova make sense to you?
It does.
That they should have exercised caution.
They should have exercised caution. Upon being aware. Upon being aware. Now the question is whether, as at the time the person received it in INEC, the person passed it on. That information was passed on to the man who issued the certificate. You understand? So knowledge is what is paramount here. Knowledge is very paramount here.
So we're saying that INEC was right to issue certificate?
INEC was very right, and because yes, the declaratory order.
And that the notice of appeal does not serve as a stay?
Yes, it doesn't.
And a mere application in itself does not serve as a stay itself.
That
application must be served all the parties involved, especially in this circumstance.
Yes,
INEC, and properly served
to trigger the doctrine of lis pendis. That is the position of the law.
Can the order of a court of coordinate jurisdiction invalidate the order of a court with the same jurisdiction?
It is very surprising. It is very surprising. That order from the State High Court in Osisioma, I think I was told so. Is the height of judicial rascality. Under the doctrine of precedence, we know that appeals from the High Court lie exclusively to the Court of Appeal. It is very clear under the Constitution. So, you see, these are the type of impunity that makes the average Nigerian lose hope in the judiciary. Because, and I believe that judgment is null and void Because in
That
UAC,
order,
that order is null and void. That order is null and void. Because in UAC versus McFoy, it has been held that if an act is void, it is incurably bad. There is no need for an order of court to set it aside. That one is void. It cannot be placed under any legal rule in Nigeria. It is inconsistent with the provisions of the Constitution, and to the extent of that inconsistency, it is void ab initio.
So what you're saying now is that in Abia State, there's an ex-governor and there's the governor-elect.
By operation of law. By operation of law as housed in that
In the eye of the law, which
Yeah.
governor of Abia State?
In the eyes of the law, there is a constitutional crisis. There is no governor. There's no governor right now. Because the
There's a
person
vacuum,
who,
you mean?
yeah, there's a vacuum. Because the person who ought, after that judgment and after the issuance of certificate of return to Oga, the person who ought to be sworn in before, you understand, before Oga is sworn in as governor. Because if he's not sworn in, he cannot assume office as governor.
True.
So before he's sworn in as governor, the speaker of the Abia State House of Assembly ought to have been sworn in as governor. But
the TJ is
because the CJ is nowhere to be
it's lost,
found.
but not found.
Because the CJ is nowhere to be found. That public function was not performed. So there is a vacuum in Abia State. There is a vacuum which can be cured. Which can be cured by, I believe that the AG of the Federation, the Chief Law Officer of the Federation, should issue a directive, just as it was issued in the case of Rivers State. So maybe the
CJ of Imo State,
the CJ of Imo State to perform the swearing-in ceremony, because it's just a mere ceremony.
Swearing ceremony
yes.
of the speaker?
No. The swearing-in ceremony of Oga.
No, accepted that there's a constitutional crisis. You have an issue here. So what will it cost us? Okay, what will it cost us if we said, there's a court order which is contentious? It's either way you look at it, and let Ikpeazu just hold on a bit. Let Oga hold on a bit. The speaker should act pending the resolution of the. It might sound a little bit pedestrian, but I don't think that at this point that might solve the problem.
But it has no foundation in law. Somebody has been issued with a certificate of return. Somebody has been issued with a certificate of return. In equity, because equity sees has done that which ought to be done. In equity, he is the governor. But constitutionally speaking, he is not. You understand? I would want to be cautious. I want to be cautious.
In equity,
Oga is governor.
Constitutionally, he's not governor because he's sworn in.
You know why I will be circumspect in making this opinion, because in Transbridge International versus Survey International, the Supreme Court has held via a short GSC that equity should not be seen as a marauding monster running around and pouring water on the fire of the law. That it is part of a system which has been missed by the law, which has been missed with the law, and that the admixture is for the purpose of achieving justice.
So whatever at the end of the day.
Now the question is this: what is justice?
In circumstance.
It is the proper administration of law in jurisprudence, the constant and perpetual disposition of legal matters to render every man his due. A judgment creditor is entitled to the fruits of his judgment. A consequential order was made pursuant to that declaratory judgment. And for me, Oga, to the extent that it had been provided in that judgment, that he should be sworn in immediately as governor. He's entitled to be sworn in.
Did you say a certificate of return should be given to immediately, or that he should be sworn in immediately? Which
Yes.
of them?
If a certificate, what is the
No. Let's get it here straightened out. I'm talking about these precise orders that was given. Yes, if it's inferred that if certificate of return is given as an equivalent, I'm talking about occupancy here because that's about land. If certificate of return has been issued, the necessary progression is that it should be sworn in.
Yes.
That's not to say that there was a consequential order or an express order. Because if you remember, in the case of Rotimi Amaechi, the Supreme Court said he should be sworn in immediately. They were emphatic on the word.
You see, they are
Now you're inferring here.
They are one and the same thing.
Okay, the program is Democracy in Action. My guest this morning is Charles Aholu, a legal practitioner. We're looking at what he referred to as imbroglio in Abia State, or the demonstration of Chris in Abia State, if we have to allow Fela to come here and analyze it. And we're asking ourselves, what is the position of the law and what is the position of sense in circumstance? So you can join this discussion by calling in 0815 5951 951, 0815 5951 951, 0817 0000 951, 0817 0000 951, 0810 9510 951, 0810 9510 951. Or you can send your text message to 0701 933 9962. Hello, good morning.
Morning.
Yeah, your name and where you're calling from, please.
This is Darlington Dobie calling from Port Harcourt.
Darlington, you said?
Yeah, Darlington Dobie.
Okay. Darlington, how are you this morning?
I'm fine.
Okay, thank you very much. Your contribution or question, quickly.
Yeah. In respect of what your guest is saying,
Okay.
he said that before the governor, Oka, must have taken power over the state, the Abia state. Now, number one, the speaker should have been the governor first, since they have already sacked a person.
Okay.
And why this very one is that the court give order that the INEC should give the person return ticket, okay, to the house as the governor automatically. It's not the House of Assembly that impeached the man, impeached the governor. It's the court that remove him. And the court is giving them like 1 day that they should return Oka as the governor of Abia State.
Okay.
So I was just trying to contribute to the question Mr. Speaker or the guest is saying. Thank you.
Thank you. God bless you. Hello. He's saying that I think he was talking about the role of the speaker, and that the speaker shouldn't. There's no room for the speaker to come in here because he wasn't impeached. That's his own interpretation of the process.
I don't think that's the position of the law. But there should be no vacuum in law.
Hello, good morning. What was that?
There should be no.
Hello.
Vacuum. Okay.
Hello, good morning.
Good morning, sir. Your name and where you're calling from, please.
My name is Stephen. I'm calling from Aba.
Your name is what, sir?
Stephen.
Stephen. Okay.
What I want to talk about that issue about and Oga. All these things they are doing in other states is delaying the work in other states and everything. Before Oga and the issue and the OKZ will be done, everything will be lazy. But Aba is no good. Nowhere to go, nowhere to move. And the Oga, I don't trust Oga. Maybe people are saying that Oga is a Hausa man or something like that. I don't know the reason why they want to remove voters here.
Okay, thank you.
I don't know the reason
Thank
why.
you, sir.
I don't know the reason why.
Hello.
Hello, good morning.
Good morning, sir. Your name and where you're calling from, please.
Hector is calling.
Sorry, Testor.
Hector.
Hector. Okay, Hector. Sorry.
Yes,
Your contribution, please. Quick one.
Okay. They said the judiciary is the conscience of our democracy.
They said, who said?
A theory. I can't.
Don't mind me. Just go
The
ahead.
theory that says it here. Now, if the judiciary is the conscience of our democracy, and in a situation where the judiciary seems to be failing our democracy, what is the way forward? Then my real question is, the court should have acted in its wisdom, because I think according to the law, for you to become a governor, you must pass through the process, the full process, the electoral process. You must undergo the processes. But in this case, the Oga, or what is called, did not pass through the process. He only ended up in the primary. And the court is now making him, ordering INEC to give
Hector,
a certificate of
Hector,
result. return.
Hector, can you just give me a minute or two here? That's how we can discuss this issue. You said he didn't pass through, that is, Oga didn't pass through the process, like he only ended up at the primaries, right?
Yes.
Are you aware of how Rotimi came into office, Rotimi Amechi?
Yes, that was...
Did he go through the elections?
Rotimi did not go through the elections.
Are you aware of the governor of Kogi State, Bello, or Yahaya Bello? Did he go through the election, the process?
The one of Kogi State?
Yeah.
Yes, he went through the election.
No, he didn't go through the election. He didn't conduct.
When the former one died and he took over.
That conducted election before the former man.
Before the full election anyway. He did not go through the full election.
Okay. Are you aware of the position of the law that says that the elections are between parties and not individuals? Are you aware of that?
I am aware, but I thought that has been amended.
Okay, you believe that should be amended?
It should be amended.
Okay, until it's amended, the law is that people vote for the parties, which means that Oga is very qualified. If the party or the court is able to justify the judgment given that he was not a fit and proper person to run on behalf of PDP.
Whichever way, I think in my own personal opinion, the proper thing the court would have done is to
order for a by-election.
The Speaker of the State House of Assembly.
Okay.
That would have been the wise decision.
That is, the law should be amended that if we have a situation like this, you should have the Speaker take position pending the proper election, right? Thank you very much.
Taking over while the other man appeals.
Thank you very much. Well, hello. Hello, good morning, sir.
My name is Marlon.
Can you just speak up a bit so we can hear you? We can barely hear you.
My name is Marlon.
Okay, Marlon. Yeah. Your question. Where are you calling from, please? You're calling from River State?
Yes.
Where in River State, please?
Precisely, I'm calling from Delta.
Degema, okay.
Yeah.
Okay. Your question or contribution, please.
With respect to the discussion on ground, I think, to me, though it's a personal opinion,
yeah, you're entitled to it.
I am some level of inter-party politics here. And politics, as we know, is all about interest.
Okay.
Therefore, what the judgments that has been given by the court on their end is okay. For INEC to issue a certificate of return is also okay.
Okay.
But for the court itself, which is judges on each end, coming to say that one supersedes the other. In a way, I am looking at it in an angle that the two parties are having a particular interest in the judgment, which is from the court. So it is only the court that can settle this issue. But the fact that they have not been able to handle this issue, and that is regarded as a vacant, therefore the speaker can come into play on the acting capacity until that process is set. Thank you.
Okay. Now, we're still having. Hello, good morning. I just wish I could have one legal opinion, one lawyer who would say that what Charles is saying is not right. Hello, good morning.
I am.
Hello, good morning. Sorry, sir. We can't get you. Hello.
Yeah, good morning.
Yeah, good morning. Are you a lawyer, sir?
I'm not a lawyer, my dear. I don't even want to be a lawyer.
Actually, I'm looking for a lawyer this morning who's going to say that what Charles is saying is total rubbish.
To be a lawyer in Nigeria, just even know the value of being a lawyer.
Are you serious?
No, seriously, because sometimes some of us that are not in that field, become embarrassing when you are seeing some of these things in this. That also uphold the high level of democracy in their institution. One judge in Abuja High Court is giving order that the governor should be vacated and giving a certificate of return to Oga. One in Soma is saying don't when I mean this whole thing is contradictory.
Please, I'd like to have you back. I just lost you in case you're listening to me. Hello, good morning.
Hello.
Good morning, sir.
Yeah, good morning.
Yes, sir.
My name is Emeka.
Your name is what?
Yeah, I want to speak on that place of.
Can you speak up, please? We can't hear you. Speak up, please.
Okay, you can't hear me very well.
Yes, sir.
Okay, sir. I want to speak on the behalf of the OKZ Bazo and the Uchoga.
Okay.
You know, OKZ Bazo has been on the scene before the Uchoga is married concerning the tax of a day. Are you getting me right?
We're trying here, sir. Go ahead, sir.
Okay. So, you know, he takes the post governor decision on this case is over because I can't say anything about Uchoga now until Uchoga will be sworn in. Now, he's not yet in also. So let him wait until the case will be over. Then we now know who will be.
Okay, sir. Thank you, sir. Thank you, sir. Yes, sir. I got you, sir. He's saying that, the Oscar is saying that, well, that's the opinion which is entitled to, that the process should be such that until everything about this, just like most other cases, come to a complete dead end and there is no other room, no other court to go to by OKZ, then you can swear, until then, it's improper for you. What if, let me just put something here, what if Oga is sworn in today, then Court of Appeal says no, the High Court was the Federal High Court was wrong. They should return OKZ comes back as governor. Oga goes to Supreme Court, and Supreme Court says no, I think the Federal High Court was right. That kind of carousel, that kind of movement, is it good for our law and the psyche of the people and development?
I think with policymakers should frame up a legislative policy to that effect. I think they should duplicate what we have in Section 143 of the Electoral Act, where appeals operate as a stay.
Okay.
You understand?
Okay.
Pending the hearing of the petition, the full determination of the petition in the final court of appeal.
Okay.
You understand? I think they should duplicate that provision.
But
people are mixing it up. Section 143 is not applicable to this pre-election.
No, that's a pre-election matter.
Yes,
it's important to highlight that because. But what I think Trump, like the last caller said here, was that to avoid this kind of scenario with this backward and forward movement for the benefit of the people and consistency in government,
it's a suggestion.
That's important that we look at how to avoid this.
I agree with
that we don't avoid the scenario of go out today, come back tomorrow morning. Let me quickly run through some text messages here. There's one from EOK. He says, "Good morning, Honorable Wenenda. No, my friend, I'm not honorable. So I don't want to go to court and remove the next day and I come back the day after." The INEC issuance of certificate of return to Dr. Oga to be sworn in as Abia State Governor in place of incumbent Governor Dr. Igbazo is right only if the certificate was issued before notice of appeal was served on INEC. Again, the Osama High Court having the same cognate jurisdiction with Federal High Court is wrong in deciding contrarily. INEC is not concerned with 21 days running available to Dr. Igbazo, as this is between Dr. Igbazo, the Federal High Court, and the Court of Appeal to sort out. As it is either Dr. Oga is sworn in or he goes to Court of Appeal to give correct interpretation of the whole saga. However, Dr. Igbazo can still vacate the governor's seat while his matter is going on and can retake his position if the court rules otherwise, as happened to the ex-governor of Anambra State, Peter Obi. I think he was out of office about 14 years or about.
Yes.
So there's no big deal if Igbazo decides to just step aside.
There is no big deal, and I think even the application for stay, I think it does not apply to declaratory judgments with respect, but it can apply to a consequential order.
Okay.
You understand?
Okay.
I think that the fact that a certificate of return has been issued to Oga raises a presumption of regularity. So it raises the presumption of regularity.
Okay. There is a message from John Peters. I'm sure it's from Akwa Ibom. It's from Calabar. He's a Calabar man. Barrister, please kindly explain the position the amendment of the Electoral Act. I'm just trying to make some little elaboration. Kindly explain the provision, the amendment of the Electoral Act that cannot allow anyone to be sworn in as governor if he has not passed through all the electoral processes ranging from primaries, clearance from INEC, participating in the main election, etc. Did Uche Oga pass through these processes? Meanwhile, is this matter not eligible to go to appeal and Supreme Court before any attempt to swear in Oga? With the Abia and yesterday judgment given to Sharif regarding Edo and Ondo States election, what is Okona Bank trying to achieve? But we cannot speculate on what Okona Bank is trying to achieve here. What we're discussing here is the law, what the law says, and the law says that if the processes are not properly served, Oga is the governor. If the processes are properly served, then INEC shouldn't have issued the certificate of return.
Yes.
Good morning, Wenenda. I pray God gives you grace to sustain the integrity of this program. It has indeed separated itself from others, from Kano, Port Harcourt. I hope it separated it for good, and not that the others are better and well. Thank you, Kano. I appreciate it. This gentleman didn't put down his name here. Why hurry judgment? Why hurry judgment and execution? Is appeal court the Supreme? Uche to defect to APC after swearing in? Just another speculation. One chance regime in Nigeria now. This is democratic right to air his opinion. Yes, so. If Buhari is allowed to stay, then Dr. Igbazu should equally be allowed to stay in office. From Festus Digbani. You're not talking law here, you're talking emotion. Godwin, good morning. Ogoludom Baro, Monday from Port Harcourt. My question is the judge so hard in his judgment by using the word immediately? Don't you think the judge in his judgment has denied Ikpeazu the right of appeal against the judgment? I guess we dealt with that because the law does not say that once an application is made for appeal, right?
Yeah, once the notice of appeal has been filed.
Yes.
That it operates as a stay.
Yes.
That's not what the law says.
He has his right. He will still pursue it up to the appeal, I guess. And but this is not for us to pass judgments on here now. Hello, good morning. Anybody there? Hello. Hello. Hello.
Good morning, sir.
Good morning, sir. Your name or where you're calling from, please? Sorry, sir.
Yes, thank you, sir. I'm calling from Port Harcourt.
Okay.
Well, firstly, I want to thank you for your good job in educating us in such matters. But my question now is this: some of these judges, by the time they issue some of these orders,
yes, sir,
do they realize that they have a superior court like the appeal court and Supreme Court that can retry a matter, retry such matters after their own court? Because you can now see that the problem is based on the order he issued. And that if the other man is the Abia State governor is being denied of his right.
Okay.
So my question is, how do we handle such a matter? That's just my question.
Thank you. I think Charles, you need to handle this bit. Just do a run through with this conception that Ikpeazu is being denied an opportunity to ventilate his case.
No, I don't think he's been denied.
You see what the callers and both the ones sent text messages and all of that.
See, I think we should draw a line of distinction between emotional ejaculations and the positions of the law. The law is clear that a notice of appeal does not operate as a stay of execution, and the mere filing of a motion for stay does not in itself operate as a stay. You understand? And then the question we should even look at this, the whole essence of even the stay of execution is to preserve the rest.
Okay.
Now the question is, what is the rest? The governorship of Abia State.
Okay.
Now the question you should ask is, under law, that governorship position is supposed to be a corporation sole. That means it is a position that exists in perpetuity. You understand? Anybody can occupy that position. So it is not, the position of governorship of Abia State is not a permanent future for the benefit of any political party.
Okay.
Yeah, it can go anywhere. Yesterday it was PDP, today it is APC. Tomorrow it could be PDP, next tomorrow it could be CPC. You understand? So that is the position of the law. People should separate sentiments and emotions from the positions of the law.
Okay. Have you covered there? Hello, good morning.
Good morning.
Yeah.
My name is Mamfani Tomaba.
Yeah, your name. Please go ahead and make your contribution, please.
I want to know if the lawyers of each organ will be able to establish the fact that the order giving Abuja Airport to issue a certificate of response to order. And the order giving to Isioma, order giving from Isioma Court, that they should not say if they are not different orders. But if they are two different orders, I think they are sort of different jurisdiction. They have right to be two different orders. But if they are the same, or if they are not the same, I mean, there's a case here. So I want the lawyer just to establish the fact that there are two different things. Because this one said, issue certificate of return. The other one said, don't swear in. I don't know two different things.
Okay, Charles.
I don't think they are two different things.
Okay.
You understand, because they are pertain to the same subject matter, and the question of swearing in is incidental to the issuance of certificate of return. So they are the same matter in substance.
Just message from Wilson, Port Harcourt. He says the High Court was right in its judgment, but wrong in giving an order for Oga to be sworn in. Allow the Supreme Court to give the final decision. Amechi was made governor by the Supreme Court. Well, I guess we'll address that. Peter from Oyibo. Wale, good morning. In all, have we in the East asked ourselves whether all these court cases here and here is applied in the North? Sorry. Why can't Oga wait for the remaining period? Whatever. Okay, it's Oga he's talking about. Well, the man has only gone to court to go and interpret the full benefits of his rights, and that's what is at stake here, not whether he's waiting for a time period. We're rounding up here, Charles. What do you think is the way out?
I think the way out, just like I mentioned, is for the AG, as the Chief Law Officer of the Federation, to issue a directive that Oga be sworn in by the Chief Judge of maybe Imo State or Enugu State or any of the neighboring states that are both Sabia. That is the way forward, because since a certificate of return has been issued to him, there is a presumption of regularity by virtue of Section 167 and Section 168 of the Evidence Act.
Is it within the rights of anybody to say that order by the certificate that was given in error, therefore I won't swear in?
No, it is not. That regularity, the presumption of regularity is rebuttable, but you don't rebut it. You don't rebut it except in court. You rebut it in court.
Okay.
By showing evidence
that order was
given in error.
Not the issuance of certificate of return was given in error.
Yes.
And therefore the swearing was not valid.
Yes.
Okay. Thanks, Charles, for being here this morning.
Thank you very much.
It's a very long issue, and I wish we had all the time in the world. For those who've been trying to call, I'm sorry we can't take all of the calls that are coming in. We hope that those who had the benefit got the kind of response they want, and then that people are equally listening. This whole issue of this whole judicial rigmarole has its effect on the ordinary citizen, on the democratic process, and the earlier we found ways to resolve this issue, the better for the people, if democracy is actually about the people and not self-service. My name is still Kingsley Wenendawale. Charles Aholo, thanks for being here with us this morning. For those of you listening out there, thank you for being there and being patient with us. I hope to be here sometime next week, same studio. You have a wonderful afternoon. God bless you. Bye-bye.